Well, hello again, and welcome to another special event from the Alliance Against Seclusion and Restraint. My name is Guy Stevens. I'm the founder and executive director here at the Alliance Against Seclusion and Restraint. And if you're not familiar with us, I started the Alliance Against Seclusion and Restraint to raise awareness about the use of restraint and seclusion in schools across the country and really even beyond. Our mission is to educate the public and to connect people together who are dedicated to changing minds, laws, policies, and practices around the use of restraint and seclusion, and ultimately see these practices reduced and eliminated in schools throughout the nation and beyond. Our vision is really to see safer schools for students, teachers, and staff. We're really excited today to have another great presenter. We've got today joining us Ron Garrison for a special presentation. We're going to be taking your questions today at the end of Ron's presentation, and we'll have plenty of time for questions. But feel free to post those in the chat at any time. So anytime a question enters your mind, feel free to post that, and we will address it as we get to a point in the presentation. I also want to let you know that we are recording this, so this is live, but it will also be made available on Facebook, YouTube, and as an audio podcast that you can download. And we try to do that as quickly as possible. So if you can't make the whole thing, we'll have this available for you to watch later. But before we get started with our introduction of Ron, I want to go ahead and introduce to you our co-host for the day, Jennifer. Hi, Jennifer.
Hey.
So Jennifer is a wife, a mother of 4 wonderful sons, 2 of whom are autistic, a 30-year political activist, who makes the world a more beautiful place for more people. She's lobbied on the federal and state level and organized rallies and civil disobedience, committed to societal change, and believes we live in a system where people have great power. Jennifer is the director of advocacy here at the Alliance Against Seclusion and Restraint. She does a lot of our social media and the amazing memes that you see and the messaging. Jennifer, welcome.
Thank you. I'm glad to be here.
Yeah, excited to have you here today. And we've got a great interview on tap here. So with that, let me go ahead and bring up Ron Garrison. And Jennifer, I'm going to ask you, if you would, to go ahead and introduce Ron to our viewers and listeners.
I'd be glad to. Ron Garrison is an MA and MS, is a former public school teacher, school safety consultant, and expert witness in civil litigation. As an expert witness, he has participated in 85 court proceedings, many involving special education students. Because Mr. Garrison is not an attorney, he cannot comment on individual cases, but he can explain his courtroom experiences and assist participants with their understanding of civil litigation. During Ron's diverse professional career, he taught public high school, was director of student services for a school district, trained teachers and school administrators in safety, classroom supervision, conflict resolution, and violence prevention in 38 states and Canada, worked with the United States Department of Justice and Education as a school safety.
Oops, looks like she's froze there for a second, but I'll finish that sentence. As a school safety expert, as I recall, advisor, you train police and school security, consulted with the jail and prison medical staff in 7 states, testified as an expert witness in 85 litigation matters, and introduced teachers and school administrators to resilient-based student interventions, created a law academy, and advocated for restorative justice programs. And Jennifer, sorry, I see you're back now.
Was I done? Oh, I was like,
you dropped off for a second, so I just picked up with your next word, hopefully, or I might have repeated the same sentence over again. We'll never know. But Ron, thank you. We're so excited to have you here today. I was really excited to have an opportunity to meet with you a few months ago and learn about your work. And of course, I read your interview in Emma Vandercliff's book and really was excited about all the stories that she wrote about you as well. So we're really excited to have you here. I mean, we talk about restraint and seclusion, obviously, a lot, but this is really a different angle. I mean, we often talk about, alternatives and better ways of working with kids. But I think it's really important for, for parents and individuals to know that there are other ways of addressing these issues. So we're really excited to have you here today.
Well, thank you, Guy, and thank you, Jennifer. And I would agree with you. There are alternatives to what we can do in the classroom and within the school and the school district. And one of those alternatives would be this notion of litigation. So what I wanted to do today was to simply give an overview of what litigation means. The law is complex.
Yeah, and I'm going to go ahead and bring up your PowerPoint presentation, and we're going to
Okay.
have you go ahead and take it away, and we'll be here if you need anything. Just give us a shout. So
Sounds
let me
good.
go ahead and bring up your screen now, and everybody now is seeing your screen and you. So I'm going to disappear and let you focus on this great presentation.
Thanks, Guy. Well,
Yep.
don't entirely disappear.
I won't go too far.
And again, Jennifer, and we'll talk a little bit about Jennifer here in a moment. But what I indicated is that earlier was that litigation is one of those things that scares folks because we don't know a whole lot about it. And I thought if I could contribute to this process of against aversive harm caused by restraint and seclusion, sharing with people as a primer for civil litigation might be a way to go. And as I often say, you don't restrain what you understand. So the idea would be to create more understanding regarding this one option of civil litigation. Now, I want to say that I don't necessarily advocate civil litigation because it is difficult and it is complex. And because I'm not an attorney, I cannot comment on individual cases, but I can explain my courtroom experiences as a retained expert and assist participants with their understanding of civil litigation. The key to all this is if you have a concern, always ask an attorney. That's the simplest and easiest method to proceed in the area of litigation if you're having an issue with your child in not only a special education environment, but also an other institution to help perhaps underscore the necessity to change policies, procedures, practices, and laws relative to restraint and seclusion. So let's start with asking the question, what is a lawsuit? A lawsuit is a civil action brought in a court of law in which a plaintiff, a party who claims to have incurred loss as a result of a defendant's actions, demands a legal or equitable remedy. The defendant is required to respond to the plaintiff's complaint. If the plaintiff is successful, judgment is in the plaintiff's favor, and a variety of court orders may be issued to enforce a right, to award damages, or impose a temporary or permanent injunction to prevent an act or compel an act. And this is your first learning because a lawsuit is not just about money. And when people think of a lawsuit, they think of money first, and that's not necessarily the case. Lawsuits can change policy, they can change practice, and they can change law. The Seventh Amendment really covers aspects of law in this country on the federal level and was really taken from a practice of English common law, focusing on civil claims and ensuring that those civil claims, at least again on the federal level, have the opportunity for a trial by jury. So what is an expert witness? That's again coming back to what I did within the courts as a court officer, is a retained expert. By retained means that we are paid. It's not by subpoena. We don't have to be in court because the court subpoenas us. We're in court because, well, again, we do have to be there, but it's because we are retained to be there. It's a person who has been recognized and is a reliable specialist who has the knowledge, skills, or experience in a particular area under consideration in a court case. In my particular situation, it would have been teaching, school safety, and special education. The role of the expert witness is to interpret factual information and form an independent and impartial opinion in the form of a written opinion, deposition, and court testimony. An expert can help or hinder your lawsuit. We'll talk about that a little bit later. So what an expert really does is that they gather evidence. They're hired by an attorney, not by the parties, not by the defense individuals or plaintiffs, but by the attorney. And from that opinion, we usually then are quizzed using what's called a deposition. I'll share more about that later. And ultimately, we end up in court and testify regarding our opinion. Usually, the retained expert is not an attorney. In civil cases, experts increase their perceived objectivity by having a record of assisting both the defense or the plaintiff in different cases. So some experts are only experts for the plaintiff. Some experts are for the defense. In my particular practice, I made sure that I was both because it seems that you don't have conflicts of interest more if you serve the interests of both the plaintiff and the defense. Only attorneys retain experts. So Jennifer can't go out, for example, regarding her lawsuit and suddenly hire me. I'm only retained by attorneys. Parties to the lawsuit are usually aware of experts, except during are usually unaware, of experts except during trial, and normally have no interaction with experts before, during, or after trial. Obviously, the reason for that is for objectivity, so that there can't be any influence on the part of defense or plaintiffs. You're supposed to be objective, even though you're hired by one side, but that objectivity carries over to both the attorney that hired you and the opposing counsel as well. How the choice of litigation works to assist in the reduction of restraint and seclusion within the institutions. And this is really why we're here today, to talk about issues of restraint and seclusion. And this is how litigation can grease the wheel and help ensure, at least in the future, hopefully, that we have much more limited seclusion and restraint than we have in the past. Civil court decisions, in addition to monetary compensation, can provide guiding insight that local, state, and/or executive and legislative branches can act upon. Synergies between social movements and litigators have led in the past to innovative litigation tactics and some very novel remedies. In some cases and in some jurisdictions, a court may order summary judgment in order or order defendants to revise policy and/or practices. If you're a plaintiff working with the plaintiffs and suddenly you receive an email or a memo from counsel indicating that the other side has achieved summary judgment, that's essentially the end of the lawsuit. Again, we'll talk more about that later. Successful court litigation can have the effect of modifying existing local policies and procedures for everyone, not just the plaintiff, since an institution or person normally does not want to produce more lawsuits. And this is important when we get to special education and things like administrative orders and that sort of thing, because generally those issues focus on the individual family and the individual student. Lawsuits tend to be broader than that. Court case information and decisions are sometimes made available to the general public through the press and other means to increase awareness regarding the impacts of restraint and seclusion. Lawsuits can also influence governing institutions toward further reduction and elimination, as in the federal Keeping All Students Safe Act, which of course a passage of that particular act is pending. Now, Jennifer is with us today, and Jennifer is part of a lawsuit that you see over on the right-hand side. This is called a complaint, and you have access to this entire complaint. It goes on for a number of pages, 56 pages, in fact. And you can gain access to, on the WAMU website, as well as other websites, to gain access to the complaint that Jennifer was party to. Jennifer her son attended the Fairfax County Public School. By the way, that's QT that you see over on the right-hand side. And if we have time, she'll maybe talk a little bit about how that worked through for her and what the process means and whether or not there's been any progress. As an expert witness, what evidence would I use to form an opinion against restraint and seclusion? So the first thing I'm going to do when I look at a complaint, for example, an attorney would send me a complaint, that attorney or that firm has retained me as the expert on their side for the case, is that I'm going to define certain things. And in this particular case, I'm going to define restraint, being a personal restriction that immobilizes or reduces the ability of a person to move his or her torso, arms, legs, or head freely. Seclusion is the involuntary confinement of a person alone in a room or an area from which the person is physically prevented from leaving. Both restraint and seclusion are characterized as aversive or unpleasant stimuli used to change behaviors, sort of like torture, and we'll talk about that as well later. I would cite allegations of death and abuse related to the use of seclusion and restraint in public and private schools. This comes from a GAO study in 2009. A 13-year-old boy with attention deficit hyperactivity disorder at an alternative public school hung himself in a seclusion room weeks after threatening to commit suicide using a cord a teacher reportedly provided to him to hold up his pants. A 7-year-old girl died at a private day treatment center after being held for hours in a face down or prone, restraint on the floor position with multiple staff members. The staff was allegedly unaware that she had stopped breathing until they rolled her limp body over and discovered that she had begun to turn blue. And I might cite this final one. Disabled children as young as 6 years old were allegedly placed in strangleholds, restrained for extended periods of time, confined to dark rooms, prevented from using the restroom, causing them to urinate on themselves, and tethered to ropes in one public school district, all from a report from a government agency, the General Accounting Office. So I would use that information as well rolled into my opinion as I start gathering data. I would refer to studies such as, again, the GAO study, this time in 2019, about the accuracies of holding school district accountable for the records that they submit regarding restraint and seclusion. The GAO study in 2019, for example, found that there were significant inaccuracies in federal restraint and seclusion data, which is required by the federal government. As reported by local school districts for the year 2015-16, 70% of the more than 17,000 school districts in the United States reported 0 incidents of restraint and 0 incidents of seclusion. All I would say would be unlikely. Next bullet. Of the school districts that serve more than 100,000 students, 10 out of 30 reported 0 incidents. Fairfax County Public Schools in Northern Virginia, which will be the subject of the lawsuit that I indicated earlier, was among the larger districts that reported zeros for multiple years. However, following an investigation, district officials have publicly acknowledged errors. They are now reporting almost 1,700 incidents in the 2017-2018 school year alone. I would quote discovery evidence from interrogatories and witness depositions. I will explain what that means in a moment. I would name local, state, and federal laws, policies, and procedures, including visiting sites to gather evidence. Very often when I was retained, I would calendar an opportunity to actually come to the school. I would walk around the campus. I would interview teachers, administrators. I would ask questions. They would provide me with answers. And those questions and answers inevitably made it into my written opinion. Site management, including safety and supervision, past practices, statistics, guidelines, intervention, IDEA, ADA 504 information would all be part of the information that I would gather as I was forming my opinion. Site information regarding the plaintiff and others. I would also look at governing agency board records, their policies, and their administrative procedures. I would look at applicable county, state, and federal laws, such as the Office of Civil Rights, the Department of Education, regional service centers, things like that. I would look at scholarly studies, of which I will mention a few at the end of this presentation. I would look at task force recommendations, any agency, local agency reports, and I would include such federal laws such as 42 U.S.C. 1983, which discusses the issue of violations of the 4th and 14th Amendments. All right, so what do you need to know about litigation before you decide to seek an attorney? Let's talk about what it is and how it can eradicate harmful aversive practices. Civil litigation is a term to use to describe the legal process applied to non-criminal matters. Civil matters can be described as situations dealing with relationships between people or a contract dispute between corporations or other institutions. Civil litigation is appropriate in circumstances where alternative dispute resolution, sometimes referred to as ADR, such as arbitration, mediation, and other forms of informal dispute resolution, are ineffective. So let's look at the 5 types of ADR and talk maybe a little bit about why they would be ineffective in situations of restraint and seclusion, especially where there was a death or serious injury involved. So you see in this little chart, the 5 types. Negotiation. This would occur between you and I in a normal situation where we don't have counsel. We simply resolve our own conflict. Then there's mediation, which is a very flexible process that can be effectively used at any time during the course of a dispute. There's a thing called collaborative law, where both parties are represented by a collaborative attorney and both parties agree not to litigate. There's arbitration, where there's a neutral arbitrator rendering in a decision called an award after there has been a presentation of evidence. Very often, television accounts of judges in courtrooms are really arbitration more than they are court or civil cases. And then finally, conciliation, which is a neutral third party to communicate with the parties in the exchange of information and settlement options. So this is a little bit different than educators think of when they think of due process and administrative remedies, but more or less, these are the kinds of things that ADR, which can be supported by a school district and in many cases are encouraged for the parties to actually do prior to civil litigation. All right, a few little legal terms that we should talk about. There are two classifications of legal action. One is criminal wrongs. We're not talking about criminality here at all. Criminal wrongs, the government has identified a crime. And civil wrongs, that injures or interferes with another person's property, or is called a tort. Can you have both criminal proceedings and civil proceedings going on at the same time regarding a particular case? Yes, it happens, usually not at the same time. For example, if there's a sexual assault on campus and the individual has been arrested for that sexual assault, the parents and or the legal guardians come back and say, well, we would also like to engage in a civil lawsuit. You could theoretically have those two going on, usually not simultaneously, but they certainly could go on regarding the criminal wrongs and the tort. Civil lawsuits begin with the filing of a complaint in the proper court, and that complaint that I shared with you earlier of Jennifer's focuses on what it really takes to write a complaint and identifies all of the issues that were experienced by Jennifer's child and other children in that school district. A harmed person is the plaintiff, okay? And the accused wrongdoer is called the defendant. So in a criminal court, you don't have plaintiffs. You only have plaintiffs in civil courts. Defendants who lose the judgment can be ordered to pay for damages and or correct conditions that lead to the civil judgment. And this is what I'm advocating, that yes, civil action does produce monetary relief. However, what we should all be involved in is correcting the conditions that caused the complaint to begin with. A dispute can be settled even before a suit is filed. Once a suit is filed, it can be settled before the trial begins, during the trial, while the jury is deliberating, or even after a verdict is rendered. Not likely in after, but it can, and I've seen cases where that has occurred. It depends on the state and the jurisdiction. In fact, settlement is a big part of what lawsuits are about. In fact, 97% of civil cases are settled or dismissed. Before a case proceeds to trial, the discovery and pretrial phases of litigation must be completed. In these phases, each party must exchange certain evidence with one another and related motions that may be decided by the court. The discovery of information regarding aversive practices like seclusion and restraint in schools may later have a profound effect on eliminating those practices both for your child and others in the school district. And discovery is not necessarily something that would be made public, for example, when you attempt to mediate or arbitrate in a school district regarding due process or administrative remedies. The federal government and individual states often have different rules regarding cases. Decisions can be rendered either by judges or juries. And I've testified in cases where there's been simply a judge who renders an opinion and juries. And they don't always have to be 12s. In some states, there's 6. Other states, there are 12 jurors. But nevertheless, it is decided by a court official, usually a judge and or a jury. As I mentioned earlier, about 97% of cases are settled or dismissed. And they're dismissed for a number of reasons. Frivolous lawsuits, for example, are dismissed very quickly because the system is jammed up enough as it is. And a court officer and or a judge will usually look at a complaint and declare that it is frivolous and simply throw it out. However, it's important to realize that there is no way to anticipate the outcome of any case at its outset. It depends on what kind of information and what kind of statements are made during what we call interrogatories and depositions. These are two very important fact-finding opportunities for counsel being an attorney, to look at, to be able to identify what was true, what was not true. Interrogatories and depositions, especially depositions, are gathered with information that is sworn testimony. And in fact, all named parties have a right to conduct issues of discovery, which is a formal investigation to find out more about the case. The who, the when, the where, the how, the why, the what, those are all part of the questions that are indicative of interrogatories and that also occur during depositions. An interrogatory is simply a question. They are used during the discovery process prior to trial. A party to a case sends their interrogatories to the opposing party, who must answer them. Both sides then can use interrogatories, and they are considered mandatory disclosures and obviously truthful disclosures. Nothing worse than a false interrogatory. A deposition is basically a process by which attorneys gather information for a case. The deponent, the witness, I was deposed many times as a deponent. I was questioned and provide information through their account of events, my testimony as an expert, and the information I gathered during my investigation. The deponent is placed under oath and asked a series of questions by the opposing counsel. Oftentimes, additional attorneys present will also ask questions. I like this picture because it is very realistic of what a deposition looks like. And if you've ever been deposed, you will recognize this. Very quickly, there's always a recording, a video recording usually. As we go from the lower right to the lower left, you see usually this computer with all the information provided by the stenographer as part of the evidence. And then you usually see on the extreme left-hand side of the picture, that would probably be the attorney that had retained me and or one counsel or the other. Then the person raising his hand would be the deponent. In this case, it might be me. Then the stenographer there who has a dual function of not only swearing in the witness, but also writing down everything the witness says. And then finally, usually opposing counsel, who is the one who asks questions. So really the process outside of recording here involves three individuals: the deponent, the stenographer, and the opposing counsel who ask questions. In some cases, the attorney that would have retained me is allowed to ask questions, but it's more or less asked usually by opposing counsel. The major categories for a wrongful act. Now, this is law school stuff, but again, I want you more aware so that when you hear some of these terms, you have a better chance of being able to think about, oh yeah, that tort is a wrong, and then move from there. So a liability is the legal responsibility for harm. An intentional wrong is action done with the intent of injuring a person, property, or both. Damages can be compensatory, nominal, or punitive. A punitive damage award, which I think you've probably all heard about, are the ones that are in the millions and millions and millions of dollars, because for whatever reason, the award was deemed to be punitive, usually against a corporation, rarely against individuals, although there are variations on themes. Negligence, unintentional torts. This is failure to use reasonable care. And finally, strict liability. Defendant is engaged in an activity so dangerous that there is a serious risk of harm, even if they act with utmost care. Proof of both causation and damages is required. So damages are a very important part of a lawsuit. In some cases, what you'll have in a matter such as restraint or seclusion is all three of these. You can have an intentional wrong, an action done with the intent of actually injuring the student. You can have negligence, which is unintentional. Nevertheless, there was pain and harm involved. Or you can have strict liability, where everyone has recognized that the activity is so dangerous that there's serious risk of harm. And of course, that would apply, of course, to restraint and seclusion, because by now I hope that most school officials understand that there is a risk of serious harm. Evidence. The heart of the case is the presentation of evidence, and evidence has been tough to find these days, except outside of courtrooms, because keep in mind, evidence is the heart of all cases within a courtroom. The law requires evidence for your opinions. They require evidence for moving forward to ensure that frivolous lawsuits are not successful. So there are two types of general evidence, and there are variations on a theme, but for the most part, they are direct and they are circumstantial. Direct evidence usually is that which speaks for itself, an eyewitness account, confession, or objects contributing to liability, for example, a paper trail. Circumstantial evidence usually is that which suggests a fact by implication or inference, the physical location, testimony that suggests a connection of a questionable action, some physical evidence that suggests litigious activity. Strict rules govern the kinds of evidence that may be admitted into a trial, and the presentation of evidence is governed by very formal rules. Examples of evidence or proof in court includes affidavits and declarations, photographs, interrogatory responses, that what I mentioned earlier, as well as deposition transcripts, copies of letters, copies of documents, the verified complaint, the original complaint, would all be considered examples of evidence. It's also interesting to note that there's a difference between civil court and criminal court in how evidence is used. Reasonable doubt in criminal cases, if the jury or the judge has any reasonable doubt about the defendant's guilt, then it must vote not to convict. Okay, so I don't know whether he's guilty or not. I've got reasonable doubt. Well, then we're not going to convict. In civil court, however, there's a different standard. That standard is referred to as the preponderance of the evidence in civil cases. The jury or the judge needs only to decide if it is more likely than not that the plaintiff's complaint is true. So it's a different standard. One is reasonable doubt. The other is, well, we've stacked enough evidence to convince me that it's probably true. So a preponderance of evidence is a lower requirement for proof than the beyond a reasonable doubt standard used in criminal court cases. So therefore, it's much easier for a plaintiff, when a plaintiff is introducing evidence, to win their case than it would be if that same evidence were applied in a criminal trial. There are four components that every successful lawsuit must prove. The defendant owed the plaintiff a duty of care. What is a duty of care? It's a legal obligation to provide services that meet reasonable standards. The defendant negligently violated or breached that duty. The negligence caused the plaintiff harm, usually through causation, which is a cause in fact or proximate cause, meaning that there was a close connection to a foreseeable harm. And four, as a result, the plaintiff suffered injuries or loss. There has to be injury, there has to be loss, there has to be harm, okay, for a lawsuit to prove successful. You can't mount a lawsuit just because you want to prove someone wrong. That doesn't work. That's frivolous and gets thrown out. A complete civil trial consists of 7 main phases. I'll go over these very quickly. The pleading stage, the discovery and fact-finding, the trial stage, which means the jury, opening statements, witness testimony, closing arguments, a jury instruction, deliberation and verdict, final judgment, and in some cases, appeal. What are the differences between special education due process and civil lawsuit? Now, for those of you who are special ed parents, you know that you have a due process ability to ask questions and to attempt to better service your child with the school district when it comes to their special education. So some of the differences that you might find with due process as it is defined on the federal level would be roughly 75 days for that. That's usually the limit. In a lawsuit, it can be anywhere from 1 to 5 years. I worked on a lawsuit that was actually 7 years old because it was one of my first and literally was my last when I retired. Discovery. Due process is more informal. The lawsuit follows what's known as the rules of civil procedure, which is very lockstep and very specific regarding what you can and cannot do regarding issues of discovery. Relief, which means essentially it helps me achieve what I wanted to achieve. In due process, you're seeking individual FOPE or IDEA modification, which can lead to a financial settlement. See SL versus Wake County. I put that in the bottom because that surprises a lot of folks, that actually due process could result in a financial settlement. But a lawsuit can seek both financial awards and systemic procedural change. Think of a due process rightly as being something that involves your child. You're there advocating for your child, and that due process creates a situation where hopefully your questions have been resolved. Lawsuits are a little bit different in that not only can it involve financial awards if the plaintiff wins, but also it can change procedural issues that brought the lawsuit forward to begin with. Due process, as you know, again, if you're a special education parent, has an administrative hearing officer. A lawsuit is in a court of law with a judge or jury making the decisions. And regarding fairness, due process assists parents and students with their individual needs. In a lawsuit, especially multiple plaintiffs or a class action, justice is determined by evidence often used to exchange policies, procedures, and or a culture. And while I've got this word culture up, I'm not going to talk about that again, but keep in mind that at least as far as this expert's opinion is concerned, restraint and seclusion is a choice. It's part of a culture, and that culture needs to be modified. Can I bring a lawsuit against a district without first going through a due process hearing? Well, first of all, ask an attorney. But in two cases, the parents tried to bring the suits for money damages against a district in federal court without first going through due process. In both cases, the court held that a student cannot avoid going through due process hearings before bringing an IDEA complaint in federal court by limiting the relief sought for money damages. This means that even if a parent is only seeking monetary damages from the federal court, she must request due process hearing. Okay? And you see the reference to the lawsuit down below. Ask your attorney in another case. A parent usually does not need to go through any due process other than a due process hearing before filing a claim in federal court. In another case, the court held that the parents and their child were not required to exhaust their administrative remedies under IDEA on the grounds that it would be futile. This means that parents who prevail at due process under IDEA are not further required to proceed through a state's complaint resolution process before filing a court action. And you see I've cited that there. It's a Long Beach Unified School District case. A decision made in a due process hearing is final, except that either party can appeal the decision by bringing a civil action in state or federal court after the due process hearing. However, keep in mind, a judge is going to look very carefully at whether or not the due process laws and rules were followed. Part two of this is, can I bring a lawsuit against the district without first going through a due process hearing? Interesting question. If the actions of school or district officials are severe enough that those actions were criminal and or caused serious physical injury and or death of the student, a due process hearing may not be required. Ask your attorney. And this, of course, involves some of the cases that I was an expert witness retained by the plaintiff, because in the cases that I worked on, unfortunately, the students died. They were dead as a result of seclusion and restraint practices. Since federal and state laws and school district policies and practices may differ, ask your attorney about administrative remedies and due process. And your question is that child actually handcuffed like that? Yes, that child is actually handcuffed like that. Let's talk about selected case studies, some of which I worked on as an expert. We have a male, 15, public school, suffered a seizure and lost control of his extremities and bladder, later became uncooperative. The assistant principal and other staff did not provide medical attention for the seizure and instead placed the student in a prone restraint for approximately an hour, resulting in death. Death ruled an accident and no criminal charges were filed. The settlement against the school district was $1.3 million. 2 staff members trained in the use of restraints pinned the student face down. This is a male, 14, on the floor for 20 minutes after he tried to attack a counselor. The student died from brain injury as a result of positional asphyxiation. Death ruled an accident. The facility settled with student's mother for over $1 million with no admission of liability. And again, that's important because it sends a message by the press in particular that there was no admittance of wrongdoing on the part of the district. And yet, on the other hand, if I can back up, there was a $1 million settlement. Female, age 7. Teacher secluded the child in a walled-off area because she refused to do her work, sat on the top of her because she was wiggling a loose tooth, and repeatedly restrained and abused her. Student was awarded $260,000. Male, 9 years old. School was only supposed to use timeout room as a last resort to correct inappropriate behavior, but put the child in the room 75 times over a 6-month period for hours at a time for offenses such as whistling, slouching, and hand waving. The school was unlocked, but a staff person would hold it shut. The room was unlocked, but a staff person would hold it shut to prevent the child from leaving. The child's hands became blistered while trying to escape. That particular civil suit was awarded $75,000. In addition, $1,000 for every time the child was placed in the room. And I found it interesting that in 2013, I was raised right here in Northern California, in fact, in Contra Costa County, and graduated from Antioch High School. And in December of 2013, one of the highest lawsuits regarding the award for $8 million was given to families of 8 special ed needs kindergartners who were physically and verbally abused by their teacher while school administrators failed to report it for what it was, which of course was child abuse. Now, as an expert for the plaintiff, very often this happens in deposition, but it could also happen at trial. How would I answer the question, well, Mr. Garrison, what would you do instead of restraint and seclusion? And thankfully, there are many alternative approaches, of which I have broken all the rules to PowerPoint and submitted here a goodly number of those on a single piece of paper. But nevertheless, let me describe some of them. I would talk about outdated science, the fact that we are still doing rewards, consequences, punishments, compliance, control. I would attack, in my opinion, any alternative that talked about behavior. Because when we start discussing behavior, that's when we start getting into trouble. I would submit scholarly research findings on neurodiversity, safe, and trauma-informed support. I would introduce negative lifelong impacts of aversive experiences on human development. I would talk about alternatives to discipline and punishment, for example, co-regulation. I would describe the benefits of targeting communication and relationships, not behaviors. I would emphasize the impact of stress and trauma on human development. I would place emphasis on neurodiversity. I would encourage parents to submit a no consent letter. And what that means is that it's a no consent letter that essentially says you may not restrain or seclude my child for any reason. I would provide examples of de-escalation strategies, which Delahook does in her book on page 156. I would cite Ross Green's work on collaborative proactive solutions. I would offer granted integrated health, comfort, and control mechanisms, Yukuru and the blocking shields, as evidence of a way that you can resolve conflicts that occur in the classrooms and still keep everyone safe. I would show how low arousal approaches, such as confirming phrases to reduce fear and stress, are very effective if you know how to use them. And finally, a little pitch here for the Alliance. I would read Robin Roskigno's article on gaslighting, because I find gaslighting typical of how school districts usually respond to issues of parents who are demanding alternative to restraint and seclusion. I would build alternatives to restraint and seclusion by citing research. like Stephen Porges and Deb Dana on Polyvagal Theory, which is a relatively new theory talking about how we can create safe and socially engaged individuals as opposed to mobilized, agitated, frantic, or numb, collapsed, and shut down students. And if you start researching polyvagal theory, you'll find that there's this notion of ventral, sympathetic, and dorsal. The vagus nerve runs throughout our entire body. And unlike Rene Descartes, who strongly suggested that there is a complete division between body and mind, polyvagal theory suggests just the opposite, that there is a vagus connection between body and mind that influences our daily behavior. Humans also provide cues of safety and or threat through the use of voice, facial expression, posture, and other nonverbal forms of communication. So maybe that could be part of the teacher training process when you're successful with your lawsuit. I would also link seclusion and restraint to two other darker issues, and that is false imprisonment and solitary confinement. I would define it. For false imprisonment occurs when someone intentionally or wrongfully confines another person against their will. And then I would ask the question, solitary confinement is highly controversial in prisons. Why is it used in schools? And I would link seclusion and restraint to an act of torture. I talk a lot about this in Emma Vandercliff's book, Talk to Me, about the relationship between seclusion and restraint and torture. Just one mention of that. There's lots of research that indicates that that torture is just as problematic for the person who is torturing as it is for the person who is being tortured. So this particular definition, again, is from the United Nations Convention Against Torture, called UNCAT. And for the most part, I think when you look at these kinds of definitions of torture and you add in the term seclusion and or restraint, you will find a connection, I think, between torture and seclusion and restraint. A word of caution. First of all, always ask your attorney. Second word of caution, awardable costs can be capped under an applicable state law. So I don't want you seeing dollar signs in your eyes, because there are several states that cap the ability of monetary relief under some circumstances. And that limit may not come close to making the prevailing party whole in terms of what was expended to successfully litigate the case. So don't always assume, first of all, that there's going to be money for you involved, because it's not always. And then the other issue is, even if there is monetary relief, it may be not enough to cover your case. So be very concerned about that, and obviously ask your attorney questions about money. Litigation is one option to reduce and eliminate the aversive harm that accompanies restraint and seclusion. While this short introduction may increase your awareness regarding the process of litigation, litigation requires that an attorney or law firm represent you and your children in a court of law. Litigation is often difficult, costly, and time-consuming, with no guarantee of success. Again, rely on your attorney to formulate the best plan of action. Litigation can assist the general public with an understanding of issues they may otherwise be unaware of regarding restraint and seclusion. Expert witnesses can be both helpful or problematic to your case. Just ask any attorney. And successful litigation can request substantial legal relief in a number of ways, such as reducing discrimination, increasing equal opportunity, supporting constitutional rights, and ensuring the application of evidence-based interventions. So with that in mind, here are a few resources. Janet Sobel's book on litigation for anyone who's actually considering moving in that direction. Mona Delahooke's Beyond Behaviors. Emma Vandercliff's Talk to Me. Shane O'Hara, Why Torture Doesn't Work, Harvard University Press. Peter and Pamela Wright, who are specialists in education law. Laura Rothstein and Scott Johnson's book on special education law. And Jennifer Laviano's Your Special Education Rights, What Your School District Isn't Telling You. So again, you'll have access to all of this information, I'm sure, on the website.
All right, Ron. Well, this has been fantastic. Jennifer and I are rejoining you, and I'm going to actually remove your screen here. This is fantastic information. And frankly, I don't know that I've ever seen a presentation really like this before. And I think it's helpful to give people an idea. Often, as a parent or someone that might be harmed through something like restraint and seclusion, we're lost as to where to start and where we might end up. And I think the more you know, regardless of what path you end up going down, the better you are prepared to make decisions. So this is really helpful. And we want to, I just want to mention to people that are viewing right now live, we are open for questions. So feel free to put questions in the chat. I'm going to start off with one and then give Jennifer a chance to ask one. Great. And then we'll get to some of the questions that are in the chat. And my question to you is kind of piggybacking on what we were just talking about, how parents that or individuals that might be influenced by or affected by things like restraint and seclusion. What I hear you saying is that this is one of many different options. You have a unique perspective, having been an educator, having been a school safety specialist, having been an expert witness. If a parent were to come to you and say, Ron, I suspect this is happening with my child, where would you have them start, and what things might you have them do before they got to civil litigation?
Well, if it were a special education child, obviously you start with the special education department, and usually the administrator of that department set up an appointment so that you can talk to that administrator. Clearly also involve the teacher in that process. If there's an IEP coming up, look at that, ask questions within that IEP. And then from there, if you don't really feel that your questions or your concerns have been answered, now we start talking about due process, moving in the direction of some kind of administrative hearing that provides relief for that special education child. If it's not special education, clearly going to the principal and providing the principal with the evidence that you need to prove the case that your child was unlawfully involved in restraint and seclusion, and move that principal into an area of increased awareness regarding what his faculty or her faculty are doing regarding the discipline of children, whatever that means.
Mm-hmm. Yeah, well, you mentioned culture, and culture is a really important piece in the many conversations I've had with parents and individuals that have been experienced restraint and seclusion. What we often find is it's not just one teacher that happens to be doing it in a school, but it's often something that is used throughout a school or a system. And again, having some of those initial conversations to seek remedy for your child is important, but getting that systemic change is really important too. And it's certainly the opportunity for legal challenges to lead to change is good, but how else might somebody lead to a more systemic change within their school district or within their state or whatever that might be?
Well, without litigation is first of all, become an advocate for your child. And second of all, become an advocate for the process of what it takes to reduce restraint and seclusion in your jurisdiction, your state, your county. Become active. Mm-hmm. And I think that it's that active approach, that proactive and active approach regarding the elimination of restraint and seclusion being your goal, that leads you to various pathways to give you the opportunity to actually achieve those goals.
Mm-hmm. Great. Jennifer, you of course were a little bit of a star of the show here as well, getting the lawsuit that you're involved in mentioned. Do you have any questions for Ron?
I'm just wondering if there have been any direct policy changes in any of the cases in which you testified.
Yes, there were a number of them. They were compelled to, in fact, change their policies and practices regarding restraint. Obviously, if a student has died as a result of those practices, that's going to get a lot of attention. And if there is a multi-million-dollar award relative to that particular case, that's also going to get attention, especially of the school board. And so, yes, I can point to direct change within school districts as a result of those particular court cases.
Okay.
All right, great. I'm going to bring up a question here from Beth. Beth's a member of our team and also watching live. Beth said, I heard during a legislative committee meeting that the common law provides the protection of individuals who truly need to restrain someone if life/limb might immediately be lost. If restraint wasn't done, an example of a child running into the street, is this accurate? One of the major blocks to banning restraint or this is the fear that teachers, others will not be able to keep someone safe due to the restraint ban.
Well, it's right there. It's hypothetical fear. And yes, something like that could happen. But the question really should be asked, what can I do to provide alternatives to students who may engage in these behaviors? And that's where we get some of those alternatives that I listed in my presentation. We have to develop co-relationships with kids and to ensure that they don't run out into the street. So I look at all of that as hypothetical fear. Talk to me about what you really are saying. What are your real questions regarding your particular child and or the school district and or how teachers respond to children? And again, the culture of that school. We can come up with all kinds of hypotheticals about a kid being out of control. What's most important is that we identify alternatives to prevent that child from getting out of control and running into a street.
Absolutely. I couldn't agree with you more. I mean, rather than looking for other forms of crisis management, it's avoiding crisis in the first place where we can.
That's correct.
Yeah, absolutely. So I have another question I'm going to bring up from a viewer, and then I'm going to ask one. And this was, what about suing individual teachers, principals who practice these practices?
Almost always. And if you look at the lawsuit here with QT, you will notice that individuals, an assistant superintendent, for example, is named as a party within the lawsuit. So yes, very rarely do you simply see a single person or a school district involved. It's usually a list of people who were either enablers or who simply did not see the problem. And that's usually discovered during the process. That's why these complaints are usually amended several times as new information becomes available.
I remember seeing you mentioned earlier the 2009 GAO report, and I remember reviewing that. And one of the things that stuck out to me was that there was a teacher in Texas that was involved in a death, as I recall, who then went off to teach in Virginia. And it seems like there are times where the people that are involved in these situations are able to go off and continue teaching. Have you had any experience with that? And what are your thoughts? I mean, what should happen in that kind of situation?
Well, unfortunately, that person should not be able to teach again. But as you well know, the credentialing process for teachers is a state issue, not necessarily a federal one. When there are issues of personnel involved, school districts get very, very nervous because they don't want to get sued by the individual, teacher, administrator, whoever, for violating issues of personal and private information. So it is possible. Those things do happen, and we have to remain vigilant. I would suggest that parents be on hiring committees to ask those very questions. Mm-hmm. Unfortunately, in some states, there is a series of questions that you can only ask. It's a list of questions, and that's it. You can't go off script. But hopefully, if you could go off script, those are the kinds of questions that we would want to ask. Now, hopefully also within human resources, that person would be screened because references were checked.
All right. Jennifer, and feel free again. I know we have some questions, but if you have anything from your own experience, feel free to ask that as well.
So in part of your thing, you were talking about that you have to go through the due process. We in QT et al. And by the way, Clinton is just the first name on there, but it's actually, there are 6 children memorialized in our lawsuit. And then also the organizational plaintiffs represent additional kids. I just wanted to make sure people knew that there are a lot of us together in this, but we survived numerous motions to dismiss on Fry versus Napoleon, which is to exhaust due process. And the reason we did was because it was an ADA claim rather than a denial of FAPE claim. Have you found in a lot of suits, have they been able to survive motions to dismiss if they go towards ADA, or most of them IDEA claims?
It depends. It depends on the individual case and
Yeah.
the ability to the attorney. And as I indicated earlier to you, you had a good team of attorneys who
Yeah.
obviously had done this before. And so they were able to circumvent those very questions as a result of their past experience, okay, as an attorney. Both are difficult. IDEA, FAPE, they're difficult hurdles. And I could have mentioned more in the presentation, probably did too much. But for the most part, individual cases have to be decided individually. And that's why an informed attorney is your best defense or offense for ensuring that your lawsuit is successful. There's just knowing federal special education law is a career all by itself. Okay. And not everyone is versed in it, including attorneys. So it's a difficult but an individual question to ask relative to how the law actually is framed. The other thing I'll mention is there's a difference between federal court and state court. And state court can have a very different opinion of things like IDEA and 504 policies and procedures than a federal court.
So yeah, I was just wondering, I guess part of the question was that I didn't ask, so there's no way you would be able to answer it, was I'm wondering if the road towards using civil litigation on this issue is more going towards ADA than to talk about that. 80%, over 80% of the kids restrained and secluded are disabled kids, and double the enrollment of Black students are restrained and secluded. I'm wondering if we'll be more successful going towards ADA discrimination claims, but I just wondering.
Or 504 versus 504?
Yeah.
Yeah, well, obviously the discrimination is there. And because of the 504 and the children who identified as 504 tend to be more minority oriented very often in communities. It makes sense to look at that, but not necessarily again. We can look at IDEA and special education policies and procedures and use them in a way that we haven't used them before. When it comes to applying 504 or special education rules and regulations as formulated in IDEA.
And by the way, I think because I'm getting technical talking about Fry and everything, just for our audience, Fry versus Napoleon was a decision. I can't remember what year it was. It's recent, where the court determined that the parents had not exhausted all remedies through due process. So since that decision, a lot of federal court cases get dismissed, and that we knew was our biggest hurdle, was to survive the numerous Fry motions to dismiss, both in the federal level and then the interlocutory, which I can't even say, appeal to the Fourth Circuit. We survived it all. We're still on a roll. So, but that's the hardest hurdle, to stay up over that Fry.
Yeah, and your team of attorneys were very aware of that. There are several sections within your complaint that directly address those issues. So they were aware of that, as well as 42 U.S. 1983. Yeah.
All right. So I'm going to get to a couple comments and questions from our audience here. And this one comes from Alicia, who's a special ed mom and lawyer in upstate New York. And her son was restrained almost daily, sometimes multiple times a day, before they pulled him from school. And the school said that he liked being restrained.
Yeah, I'd like to know who they is.
Yeah.
I just, since I equate torture with restraint and seclusion, I find that hard to believe. I would use this in my opinion. If that were actually a quote by an administrator that he liked being restrained, I would absolutely use that and document it in my opinion.
Yeah, and it goes back to what you mentioned about Robin's article about gaslighting.
Yes.
We have often seen seclusion rooms called things like the blue room, the calm room, the fun room. I mean everything but the torture room. And same with restraint. We've heard restraint. It's a therapeutic hug.
If it walks like a duck.
Right. But there's absolutely a lot of that going on. So let me see what else we have here. Let's see.
I see a question I'd like to answer.
Okay.
By Candace. Is restorative justice relevant to this at all? Absolutely. Restorative justice, I think, is a mechanism that is very appropriate. And I utilized in my own classroom, especially within the law academy, when children were involved in behaviors that were not on the lesson plan. I stopped the lesson plan and we all formed a circle within restorative justice manner. And we talked about it. And we talked about what effect let's call it an interruption would have had on the rest of the class. So I find restorative justice relevant in many, many ways. And thank you, Candace.
Yeah. Well, and it gets to one of the things you hit on earlier, and it's one of my big things, which is it's all about relationship. When you restrain or seclude a child, you are not building a relationship. My son remembers the man that restrained him in 5th grade today. If he sees him, he remembers who he is. You destroy relationship by doing these things. And, I always joke that the 3 R's of education should be relationship, relationship, relationship. Restorative programs, co-regulation, all these things, Ross Green's collaborative proactive solutions, they're about maintaining relationships.
Absolutely.
Yeah. So I do have a couple people have asked if your PowerPoint will be available. Of course, I want to remind people that we are recording and we will make the whole presentation available. But folks wanted to know if your slide decks might be available as well.
I can send them as a PDF to you, Guy.
Okay. Sure, that's fine. And if somebody wants them, they can reach out to me by email. You can do Guy Stevens, and that's GUYSTEPHENS at enseclusion.org. I'll put that in the comments as well. And with that, we've got quite a few more questions and comments. But let me go ahead and ask one of you now as well. And you asked one of the important questions to me, which is like, what else should schools be doing? But let me ask you the other part of that question, which is, I don't think any of us are anti-teacher, anti-educator, want to blame anyone. We want to fix and improve the system. We want to work with people to make differences. But why do you think that we find pockets where restraint and seclusion really seems to happen quite a bit more, and in other areas they don't seem to use it at all?
Right, and it's culture. It's how we've always done things. It's the way we deal with children in this particular school. And I don't see a whole lot of teacher training programs that provide alternatives to those issues and to that culture. And so as a result, we find that we have lots of kids engaged in activities and lots of teachers engaged in aversive activities against those children when those kids are perceived to be out of order, bad, non-compliant, because after all, as a teacher, I'm supposed to be in control. And I think I would like to go back to the teacher training institutions and say, no, do not train teachers to think that they have to be in control. They are there primarily to guide young people's education, especially in this digital age. They are more now facilitators than they are teachers. And if we can start with that, we can move this process forward in a way where restraint and seclusion becomes a dim memory.
Yeah, I look forward to that.
Yes.
Jennifer?
I had a question when you were talking and but going to the culture piece. Oh, this was my question. I've read training materials of some of the companies that teach how to restrain and seclude. And it occurs to me, the culture doesn't start at the school, the culture, and it's based on fear of children, basically.
Mm-hmm.
You read the materials for those companies training, sounds like these people are going to be going into school and dealing with rabid dogs, instead of children. And do you think that culture of fear, I mean, it starts before they even step into the building, if they've been trained by some of these companies like Handle with Care, or some of these other ones are just.
Well,
Okay.
it supports discrimination. If you don't look like me, and I haven't been trained appropriately to be able to respond to you as a human being, but as to someone who is different, has different values, all those other things that I frankly can't handle about you, then that's going to affect my behavior toward you. Yeah, the disproportionality of discipline for kids of color is not an accident.
Yeah.
That there's a reason for all of that, and part of it has to do with culture. Part of it has to do with my own inability to respond to what's happening around me. Part of it has to do with anger and, frankly, non-professional responses to the children under my care. So we have to profession up our staff to help them understand that this is a new age where we don't need to restrain children. We have other alternatives.
Yeah. Well, I think that even a lot of the word, I mean, I hate to plug my main thing, but the words that we use about kids, aggressive and challenging and violent, and, and it's just, why not distress and challenged? And, it bothers me that children have become these fearful creatures. So,
Yes.
All right, a couple more questions and comments here. This one from Dana says, how can we retain you to represent our children? Of course, I remember you saying that lawyers hire you, but if somebody's aware of you and they happen to be involved in a lawsuit, would they point their attorney in your direction, or how do attorneys find experts?
No, I would, well, in my case, I would strongly indicate that I'm retired. Okay?
Right.
Yeah.
That's one problem. Yeah,
that's one problem.
For you.
You're best to not deal with experts at all, because then there's an influence issue there that you don't want. Experts are supposed to be, by definition, objective. Okay. And any contact made by any of the parties outside of an attorney is seen as compromising. Okay. So I guess, again, the best answer to that is you can't retain me. You might recommend a person that you know as an expert to your attorney, to your lawyer, but that's the most you can do.
I recall, and I could be totally wrong here because this is a random recollection that I don't know what it connects to, but I recall learning about expert witnesses and learning that there were directories which attorneys would use to find expert witnesses. Is that correct?
Absolutely. And so what happens is that an attorney or a firm or a law firm, and I remember the last one I got, it was about that thick, of registered experts. And these are individuals who have worked in the courts previously. They have built up cases within their CV, their curriculum vitae. They are recognized in their field. And some of these fields are extremely small. In fact, the smaller the scope of the expertise, the larger the retainer. But nevertheless, it's one of the situations where those attorneys have access to those individuals and that book or several books like that. So if they're looking for an expert in special education, restraint and seclusion, they would go to that appropriate page, and you might find 3 or 4 individuals, of which then they would call them up, they would briefly interview them, and based upon that brief interview, they would then retain or not retain that particular expert. So whatever the field is, there is an expert out there.
And are there ways of determining whether or not I just wonder how they determine if they're good. You mentioned kind of the importance of being impartial, and I only have done jury duty a limited number of times in my life, but I remember doing it at one point. There was an expert witness, and he kept referring to we and talking about the I guess he was talking about the plaintiffs, as I recall, but he kept referring to as we, and that kind of struck with me his credibility, because it seemed like he was no longer being a separate expert witness, but it was part of the case.
Right.
Yeah.
And even though you're retained by one side or the other, you still have to maintain objectivity. And I made sure I always did. That's why I was able to work with both sides. And just like everyone else, attorneys talk to other attorneys. And one will call up and say, I need an attorney in school safety. Yeah, just a couple months ago, I used this Garrison guy. He's a generalist in school safety, but he has this background, and I think he might be very appropriate for your case. Give him a call. Here's his number. So more often than not, it was word of mouth. But if there was no relationship there, then they would go to the directory, of which I also did, and that from that directory they would pull my name. But you're right. By definition, an expert witness is to be objective. You wish it could be that way, but of course, if I'm being retained by you, I'm probably going to lean more in your direction than opposing counsel's direction.
Right.
So it's a fine line. Let's put it that way.
Gotcha. Are there ever cases where an expert witness is used and because of what they're, I mean, in any process and meeting with the attorneys, they decide, well, maybe this isn't our guy. I mean, if that expert's not, okay. Yeah.
Right. Absolutely. And that can usually happen during deposition or after deposition, because that's where you really get to know an expert. Okay. But it could also be at a time at which I'm formulating an opinion. If an opinion in a complex case is 3 pages long, and I've billed you 85 hours for those 3 pages, you probably know that something is wrong. And you'd pick up the phone and talk to me quite seriously about what is all this stuff. And again, there was this one expert I recall, she said, yes, I'm an expert, but I never testify in trial. And of course, this was an attorney's story, and they just hung up on her because that's ridiculous. If you are an expert witness, not only do you formulate your opinion, not only are you deposed upon that opinion, but you testify on that opinion in court.
Okay. I'm going to bring up a couple more questions here from our audience, and then we'll get back to you, Jennifer. This one asks, is there a pathway to legally prevent these actions by making them unconstitutional as applied to all?
Well, funny you mentioned the word all. Thank you, listener. We've got current legislation on the federal level now that effectively, yes, thank you, Jennifer, she's jumping up and down, that essentially addresses the issue of restraint and seclusion, not necessarily making it constitutional, but making it certainly part of the federal evidentiary procedure relative to restraint and seclusion. And of course, as an expert, I would use that. I would use that in court and say, gee, you restrained this child in this manner. Do you realize that's a violation of this current act and or law? And that becomes very powerful to advocate for the case.
Another question here related to the Keeping All Students Safe Act. Just are you at all involved, or will you be involved in any, I mean, you come out very strongly here in talking about torture. Are you involved with CASA in any way, or have intent to?
No, and I hope to not be involved, to be honest. I guess if drafted, I will serve. But the bottom line is that other people can make these connections. There are lots of folks that are talking about the relationship between restraint and seclusion and torture. And I also think solitary confinement is another avenue that needs to be addressed here. Clearly, forget the prison to school pipeline, if it's controversial to talk about solitary confinement within a prison setting, how can we even think about it within a school setting? And those kinds of dots, I think, can be made, can be connected by folks who just, maybe I've planted a seed. Now we can start thinking about how torture is related to restraint and seclusion on a 7-year-old child. I don't think it's a huge stretch.
Yeah.
And I talk a lot more about torture in Emma's book, Talk to Me.
And Jennifer, I promise you that I get to your question, but we had a shout out for you. Thank you. You're amazing. So that's a good segue to your question. I will also say, we mentioned the book a couple times, the book Talk to Me, where Ron, you've got a lengthy interview in there, and your stories are mentioned several times in the text as well. So a very good book to read. So Jennifer, what do you have for us?
I would love for you to talk more about the connection, or if you feel there is one, I think you do, between behaviorism and restraint and seclusion. I was just having this conversation with someone this morning who's a behaviorist, and they said that they have nothing to do with each other. And I beg to differ. What do you think? Really?
So operant conditioning has nothing to do with restraint and seclusion? Well, obviously, I think it does. Obviously, there's a thread that suggests, at least in my mind, that behaviorism is a direct result of punishments and consequences for children who are outside of the realm of normal. Okay, and that, of course, includes children who are in special education, who are by definition neurodiverse. And just as we talked about disproportionality of minority kids, so too do we need to talk about the implications of neurodiversity in our schools and help people understand that within the spectrum of neurodiversity, behavioralism is a tough nut to crack because it ultimately reduces to itself to these are bad behaviors, and those bad behaviors need to be corrected. And the minute you talk about correction, you're talking about control.
Yeah.
And the minute you're talking about control, you're talking about restraint and seclusion. So I would, along with you, strongly argue that there is a significant connection between restraint, seclusion, and behavioralism.
And most of the people with whom I was speaking said, but ours is positive. This is the new kind. And, Alfie Cohn's punished by rewards,
Well,
so
Alfie,
something, but I'm not,
Alfie was one, I think, the best articulator of the difference between punishments and rewards and how they all fit into the behaviorist scheme. I think we're better than that now. We've got other alternatives.
Yeah.
We can do better than behavioral response to children, of which I have just mentioned a few today.
Mm-hmm. So we have your presentation has sparked a tremendous number of questions. I would say probably more questions than I can remember getting in a presentation ever, perhaps. So we've got quite a few, and we've got a little bit of more time left. So I want to try to get through a few of these. But first, we are joined here today by a rock star, Emma Vandercliff. We've talked about her a couple of times, and we've talked about her book, Talk to Me. We previously had done a really great presentation interview with Emma. And she asked a question. You talked about the changes on human brains in my book. Can you say more?
Hi, Emma. Hi, Norman. Yes, I can say more to that. There are lots of studies on torture, and torture is clearly a stressful activity, and that stressful activity, interestingly enough, has significant implications for not only the person who is torturing, but the person who is tortured. And there actually are changes that occur, and you can read all about it in, hopefully I grab the book, in Why Torture Doesn't Work, The Neuroscience of Interrogation by Sean O'Mara. And I think that's as far as you need to go. One look at that book and you'll have a real understanding of how changes in the brain are the direct result of stress, right, and the stress related to seclusion and restraint.
Absolutely. So I'm going to get to a couple more here. Our friend Alex, he said, I always felt helpless and that the teachers that emotionally abused me got away with it all. So my question is there a way to call them out even decades after not seeing them, at least if I remember their names? So, Alex went through a really negative experience, and, I was wondering, at this point in his life, is what he can do. I mean, certainly getting involved in helping to change things is positive, but do you have any other thought on that?
Yeah, Alex, I think that's where I would go with this. You need to find support with other people and leave this issue behind you. Do what you need to do to ensure that you're not having feelings of calling anybody out on these issues. Again, there are lots of things that you may not realize. Personnel issues, issues of retribution on the part of that person if you called them out. Lots of things that could turn violent without you expecting them to. So I would say at this point, move on with your life. Do things that are positive. Become an advocate. Become an expert witness, having experienced these things yourself. And take that energy and direct it in a positive direction.
Absolutely. And I want to
Greg is an autistic self-advocate and political activist. So, and he's been working with us, but I'm sorry, I didn't mean to interrupt.
Yeah, no, absolutely. No, Alex is definitely doing that and trying to influence a positive change. I want to bring up one, and this is an important one. This is from an educator, and she's been an educator for 14 years. almost exclusively working with students receiving special education services, has been certified in MANT, CPI, and handled with care, and has encountered a lot of resistance when she avoids using restraint and seclusion, even when there's no risk of bodily harm. So the question is, how can I protect myself professionally when the culture may be averse to ending restraint and seclusion?
Yeah, Heather, I understand what you're saying. Are there interdistrict transfers available for you? If you have a culture within a school that says that you are not a good teacher because you're not applying restraint and seclusion in appropriate ways, I think it's time to move on. I think you need to find another school, another district. We need to have your talents in that are positive as an alternative to those issues, not where you're feeling persecuted by teachers and administrators who feel there's only one way to handle a child, and that one being restraint and or seclusion. So I think you need to find people that support you within the school. And if that doesn't work, I would looking for another school district to work for.
Yeah, unfortunately, that kind of situation is not isolated by any means. I've had many conversations with educators who, in their own schools, have come to this idea that, we shouldn't be restraining and secluding kids, and sometimes then become an outcast, or even worse, or retaliated against, and sometimes disciplined inappropriately for rocking the boat. And it really is a challenge, I'm sure. We've got two comments here in a very similar vein. And this one talks about, appreciate it when he redefined that the problem is not the person, it's the way the person is treated in systems and institutions that privilege brains and bodies over, that privilege brains and bodies over other brains and bodies. And certainly, one of the things that we hear a lot is, or see a lot, is the blame on the child. It's all about the child. And, as Emma's book illustrates, and others, often it's what we're doing that's so important to influencing the situation. I think about, people that have said things like, our own emotions and feelings are a contagion that are spread to children. A dysregulated adult can't help a dysregulated child. So I think that's an interesting comment. Do you have any thoughts on that?
Only come back and say relationships.
Right.
That's what's important here. Understanding that we can co-regulate their behavior as well as ours by simply communicating what those behaviors are, and talking about it and listening to where the child is coming from. It's almost as if we forget, and Philip R.E. in his book called The Centuries of Childhood was one of the first to point this out as a historian. We have a very different view of what children are versus what in ways we used to treat them. And I think it's important to understand that they are not the problem. Very often we or the institutions are the problem. Okay. And kids need to be supported, not destroyed by the institutions that serve their needs. And in some cases, especially in the case of a homicide where a child has actually died as a result of restraint, that's harmful. That's aversive harm that needs to be erased, never to return.
And trauma throughout the whole culture. I mean, I often talk about in my posts on Facebook is that the kids witnessing it. It's not just the person being restrained and secluded and the person doing but the kids witnessing it, hearing the screaming and the seclusion stall, seeing their friends' face.
And curiously, the same is true of torture. Individuals who observe a person being tortured by another individual carry almost as much stress as the person who is doing the torturing. And it's curious to me that in our modern culture with modern media and movies, it's difficult to find a single movie that doesn't involve some form of torture, either physical or psychological. It's almost as if it's been ingrained into the culture, so it's okay. Well, it's not okay. And there are lots of reasons why it's not okay. And we're producing individuals who have very serious deficits as a direct result of being exposed to torture.
Yeah, a lot of it relates back to kind of the trauma cycle. And in the trauma cycle, we sometimes forget affects both kids and adults that, when a kid, perhaps with a trauma history, is restrained and secluded, they're traumatized. And
Again.
and when they're traumatized again, that makes it more likely in the future that they're going to be bringing more trauma in. And of course, that then affects them feeling unsafe, feeling hypervigilant. But, I think that adults also end up in that same trauma cycle when they're using these things. It's traumatic for everyone involved, and that trauma leads to, fight or flight, and that trauma leads to everyone getting hurt. It can be the teachers, it can be the students and the staff. Anytime we're doing these things, the chance of somebody getting hurt goes up.
How can you explain positional asphyxiation if not people out of control?
Right, absolutely.
It's not only just about training. As I mentioned in Emma's book, these interventions look more like a fight to me than an intervention.
Right.
Okay.
Right.
And so you're telling me you're fighting a 12-year-old child because they're doing something that you don't want them to do. Right. That's not appropriate. That's not a professional. And I'll see you in court.
Yeah. And even more commonly, 7, 8, 9-year-olds,
Yes.
It's really, really disheartening. So this has really been fantastic. I think we're just about at 5 o'clock here, so it's about time for us to wrap it up. Jennifer, do you have any last questions before we wrap things up?
I actually just want to thank you for what you've done for kids. And I read you in Emma's book, and people like you give me hope that the world can change, because it needs to. And I really appreciate. I don't have a question. I just want to thank you for existing. That's all, and for all you've done for kids.
Thank you for that, Jennifer. Very much appreciated.
That's great. Well, Ron, thank you so much on behalf of the Alliance and our audience here. This has really been a fantastic presentation, and knowing that you're retired, I still I appreciate you making time to do this. But still I'd look forward to any other ways to collaborate with you. Certainly, I think that this presentation was resonating with people and really informative. So thank you so much for joining us today. I'm going to go ahead and give a couple announcements here, but I just want to thank you again, and look forward to maybe trying to put you on the hook again for something else. This has been really, really fantastic.
No problem.
Thank you.
Thank you again, Jennifer, and thank you, Guy.
Absolutely. Thank you.
All right.
So let me just give a quick announcement here. I want to thank everybody again for joining us today. Hopefully you enjoyed this presentation and were able to learn a lot from it. I do want to let you know that we have another presentation coming up here again in just another 2 weeks. We're keeping our regular schedule here, and we're going to have Cheryl Poe, who's also part of the Alliance, providing tips and tools for special education advocacy for those who are often ignored. So another great presentation coming up. I do want to let you know that, of course, this one will be recorded and available on YouTube and on Facebook, and to listen to us on audio podcasts. And, I want to thank all of you that spent some time with us today and that are part of this effort. Lately there have been some positive things happening. We've got the reintroduction of the Keeping All Students Safe Act. We've got a lot of people coming together for positive change. And I'm feeling optimistic and really appreciate all of you that are part of our community here. And thank you for everything you're doing. So that wraps us up for today. Thank you very much, and we'll see you next time.